Three judges have blocked President Biden's new Title IX transgender rule from taking effect in 11 states. The rule changes the definition of sex to include gender identity. That means boys who identify as girls and girls who identify as boys could use opposite-sex bathrooms and locker rooms. Well, here to explain the ramifications of these rulings is Sarah Parshall-Perry. She's Senior Legal Fellow at the Heritage Foundation. Sarah, this started with two judicial decisions against the Biden rule change, one in Texas, another out of Louisiana, and now a federal judge in the Eastern District of Kentucky. So explain what's going on here.
Yeah, we're not surprised, actually. The minute the rule came out, within 4 weeks, we saw no fewer than 9 federal lawsuits brought by 25 states, a handful of membership organizations, and a few individual plaintiffs, all of whom charging various constitutional law violations, administrative law violations, and civil rights law violations. But we've already seen 3 of the trial court judges, and believe it or not, just recently a divided panel of the Sixth Circuit Court of Appeals has also ruled to enjoin what's called informal guidance on Title IX. So it's important because while it is not an injunction on the final rule, it is a statement from these 3 judges at the appellate level, the highest we've seen so far, indicating that, yes, this administration did interpret Title IX in a way that is not supported by its text, by its congressional history, by a plain reading of the law. And in fact, I think we're going to see more outcomes like this before the enforcement date of the rule on August 1st of this year.
Well, the U.S. District Judge in Louisiana said the president overstepped his authority with this rule. How did Biden overstep his bounds? Doesn't the president have the right to set policy for federal departments like education?
He does, but he doesn't have the right to make law out of the ether without consulting Congress on it. In fact, we were just reminded by the Supreme Court last term in a case called West Virginia versus EPA that if you are going to make a rule with, quote, broad political and economic impact, you better have pretty clear congressional authority. And to expand the definition of sex to include sexual orientation and gender identity or expression, among others, is a reading of longstanding federal rights law that has never actually been found supported by the text of that particular law. In fact, Congress amended Title IX twice, once in 1975 and another time in 1987, and at no point did Congress ever think that sex should be amended to include gender identity or expression. So this is a reading really of longstanding federal civil rights law. It celebrates its 52nd anniversary this month that has never been expanded in such a way. And I am keen to think that the Supreme Court, once faced with this kind of a case, is going to determine, as it did in the West Virginia versus EPA case, that the Biden administration really got out ahead of itself and acted in a certain way that was not supported by its authority.
Well, Sarah, these judicial decisions only affect 11 states at this point. I guess most of our viewers want to know, what does this mean for them and their children?
Well, understanding that half the states in the country, 25 of them, have already challenged this rule, and understanding that now we have 11 that are shielded until an appeal from the Biden administration, it's actually good news. And it indicates that in this fast-moving area of litigation, it is very likely that we are going to see the Supreme Court make a determination on this, at least on an emergency basis, sooner as opposed to later. Now, we are coming to the end of the Supreme Court term. We will probably reach into the first few days of July, but it would not surprise me if we see on something called the shadow docket or the rocket docket, if it's as it's sometimes colloquially called, the Supreme Court making a very brief emergency determination that a law should be enjoined, it should be paused, while the merits of the underlying litigation go forward. So that's good news goes to state and local education associations that want to follow the law. They have air cover now to be able to say, listen, this law, this rule is tied up deeply in litigation. It is in our best interest not to make any change because we might invest taxpayer funding to expand facilities, open up bathrooms, install, for example, urinals in the girls' restroom that we might have to actually go back and ultimately undo. So as far as we're concerned, this is a good way to say it's time to press pause on this illegal interpretation of the law.
So Supreme Court probably intervene soon or take a case soon on this?
We may see a temporary pause from the Supreme Court while the underlying litigation takes place on the merits, and that sort of battle of the textualists versus anti-textualists in federal law takes place, and we'll see whether or not, in the end, whether or not they come out the victors, as we believe that they will.
Okay, Sarah Parshall-Perry, Senior Legal Fellow at the Heritage Foundation. Thank you, Sarah, for sharing your time and insights. We appreciate it.
Thanks for having me.